Good afternoon, everybody. I hope that those of you online can hear me well. My name is Ignacio Herrera-Anchustegui. I'm professor in the University of Bergen at the Faculty of Law. And today we're going to have a webinar with a special guest coming from Aberdeen, so not too far away, located in the sea, in the North Sea, Uisdean Vass, that has been working on different aspects of upstream petroleum, oil and gas activity for the last 35 years or so.
40.
40. So Uisdean has been working longer than I have been living in this area, literally that much. And I will introduce you in 1 second. But before we start, I would like to say thank you so much to all of you joining us online, which we have about 30-something people in Zoom, and the more than 40 that we have here in the room to talk about a topic that perhaps for the majority of us is somewhat unknown, which is this issue of decommissioning in the continental shelf of offshore energy infrastructure. Just to give a brief introduction to the topic, and then I'll introduce the speaker, and then we start with business. This is a fascinating topic that involves the question of what are we going to do with what we put out in the sea to extract the natural resources. This has served us well through decades in the North Sea, in Asia, in Latin America, in the Gulf of Mexico. And just so that you get an idea of the magnitude, we have thousands of oil and gas wells in the world, about 8,000 of them, that at some point they will need to be decommissioned because they don't have more oil and gas to be extracted, or because oil and gas activity will stop in some countries for different reasons. And the question is, how are we going to remove and put an end to this activity, what is called decommissioning? And decommissioning is a mix of energy law, administrative law, public international law, contractual law, and it's an area that is on fascinating moment at this time, because we estimate that within the next 10 years, we're talking about 50 billion euros in contracts on decommissioning only in the UK, as far as the numbers go. So this is about how we remove this stuff. Some of the things that we're working at the University of Bergen with Offshore Norge, which is an organization that groups players in the oil and gas and renewable industry in Norway, and it has been so kind to advertise and to be part of this event. We're working on how we're going to decommission, so how we're going to remove and reutilize what we are using, either in the oil and gas sector, in new sectors like renewable energy, green hydrogen, where we have Simon van Hove speaking about this last week, joining us too in the public, or also in different things such as, for instance, aquaculture. So with that being said, I would like to introduce Uisdean Vass. His name and himself is coming from the Highlands in Scotland, not too far away from here. He lives in Aberdeen, works in oil and gas business, as you have heard, for longer than I've lived, and I think longer than most of us that are in the room too, but not everybody. Uisdean, you have been working in oil and gas all over the world. You lived 10 years in Venezuela. That's where I come from. That's where we have Latino accent in common from Caracas. He has also worked in Brazil. We have a couple of Brazilian people also in the room here today. You have been working advising companies in the UK. You have advised companies also in Norway, and you have worked the A, B, C, and Z of oil and gas regulation. It's a great pleasure for us to have you here, and I'll give you the word right now, and I'll shut up and let you speak about decommissioning. The only bit is let's make sure that your mic is on.
All right. Can you hear me? You're hearing me well, and hopefully everyone online can hear me too.
Yes.
Yes. Well, Ignacio, thank you very much for that very kind introduction. And thanks to the University of Bergen for having me here, and also for Offshore Norge, who have kindly sponsored this presentation. So it's deeply appreciated. UKCS decommissioning.
Not your fault. That's people chatting.
Ah, how dare they? How dare they? UKCS decommissioning has got a number of very powerful legal and engineering challenges. And of course, I'm a lawyer, and I can only come at the topic really as a lawyer. But and not as an economist, not as a scientist, not as an accountant, but hopefully I'm at least a well-educated layman. And what I try to do is I try to keep minds open, keep asking questions that we don't have answers to. Don't come up with final solutions until we must come up with final solutions. That's basically my approach. Now, there are things that I will try to cover in this seminar and also things I won't try to cover. That sounds a bit illogical. But at the end, I will list a number of key topics that I simply am not able to cover, but will be able to speak to in the Q&A. But what I hope to do today is, first of all, to give you all a sketch of the UKCS and its decommissioning realities. At the same time, although I'm by no means an expert in Norway, I've been doing a bit of research, and I hope to throw in some comparisons with the Norwegian system. I'd like to have a brief look then at OSPAR decision 98.3, which essentially is the international rule in Northeastern Europe for how to decommission. And then I have had a very profound question. Could I get off? Could I get off coming to Bergen without speaking about tax? And I thought, no, unfortunately, I would have to speak about our tax, which is really extreme and really quite different from Norway. It's an utterly extreme system with extreme anxieties, but it is driving the whole system. So you'll have to bear with me on that front. And then I'd like to look at who is liable for decommissioning, both under our license and our statute, because we have a bifurcated, a double system of decommissioning regulation. And then I'd like to look at our agency roles, how the regulatory process actually works. And then I'd like to look at something new that was established in 2016. It's an overarching oil and gas regulation, something called maximizing economic recovery, MER, and how that fits on top of everything and how it affects decommissioning. So that's what I'm hoping to do, and I'm hoping to get through this in about 45 or 50. And Ignacio, I hope you got your red card, you're ready to intervene, because I can get out of control at times. So you're there. Yeah. So let's have a look at the UKCS in context. We're the world's second oldest offshore producing province. We started producing gas offshore southern England in the 1960s. Our first round was in 1964. So we're well ahead of Norway in actually producing hydrocarbons. But oil didn't start to be produced until the mid 1970s. And we're the world's first example of building concentrated deep water constructions in the cold, tempestuous waters of the central and northern North Sea. So we were actually leading the world in that technology, but it was very basic. So these structures are actually very heavy. You would never need to have heavy structures like that today. And many of these fields have produced so incredibly well. Forties, for example, is still pumping away like 50 or 60,000 barrels a day. Amazing old fields are still there. And the UKCS, the UK government's policy has been quite unlike Norway. In the 1970s, we had the first oil shock. In 1973, I was a 13-year-old, and oil prices trebled in a single week. It was a period of stagnation, and there was a real desire for energy security. It's staggeringly similar. The 1970s, to me, the 2020s are a repeat of the 1970s. You know, we've had the oil shock of 1973 and the gas shock of 2022. We had a new Labour government in 1974 and a new Labour government in 2024. It seems to me to be playing out again. So what we've done is to drill, baby, drill, to encourage the maximum amount of drilling as fast as possible. We've had no depletion policy at all, contrary entirely to what Norway has done. We're a very large economy with a small amount of oil. You're a very small economy with a large amount of oil. So we've got lots of new entrants. We actually got 250 licensees in the UKCS. And the government encourages deal churn. It wants new people and new ideas and new finance. And so what we've got is we've got a lot of production of small fields, and our target prospects now are mostly small. For the level of production, we have roughly 1,250,000 barrels of oil equivalent. That means both oil and gas for 300 fields. That ratio of fields to production is probably the highest in the world, though I don't have the figures. And you compare it to Norway, which is 4 million barrels of oil equivalent with around 90 fields. So if Norway was to have as many fields per barrel of production as we do, you would need almost 1,000 fields. So you have to think, you know, this is a totally different oil province. And a number of years ago, Offshore Energies UK, in their annual report, they did a study of, you know, how do you rate the UKCS and the NCS? And they looked at the Troll field, the giant Troll field. Their conclusion was that Troll was about as productive as the top 25 UK fields put together. So it shouldn't escape you that here in Norway, you are an energy giant like the United States. So clearly, with decommissioning, that has a huge impact because you've got far more structures per barrel of production. And here, as also in Norway, with many, many small fields, there's a huge level of importance of third-party access to infrastructure. So the UK and Norway are the most advanced jurisdictions in the world in facilitating the tying in of fields, but the UK the most advanced. As it happens, that is my real love, is third-party access. In fact, if I can talk about third-party access, I'll just change. Is that all right, Ignacio? No. No. I've just written the new chapter on third-party access for the new book, just coming out next year on UK oil and gas. The goal of the government, not surprisingly, is to discourage decommissioning. Keep these structures in place as long as possible because they're needed to encourage new exploration and new production. Without the structures, you doom the small fields which lie around them. So that's a bit of the flavor and comparison. Now the hubs, the production hubs, are of enormous importance in the UK. There are 30 hubs which produce 80% of all UKCS production. And these hubs are relying on new discoveries coming on stream to keep on going. And I know that from personal experience because I work on one of the 30 hubs virtually daily. And I know how important it is that we have new developments. So this is courtesy of Dundas Consultants. It's the top 15 production hubs. You won't probably have heard of them. But I just want to highlight the importance of our hubs, and including for decommissioning. We don't want to decommission these hubs. Now, the size of the national project of decommissioning, these are actually figures from our oil and gas regulator, the NSTA, from a year or two ago. So we're looking at like 350 fixed installations, 250 subsea systems, 20,000 kilometers of pipelines, 7,800 wells. Well plugging and abandonment is reckoned to be just short of 50% of the whole spend. Estimated costs for the coming decade, 21 billion, which is a pretty large chunk of change in anybody's book. So that's the economic prize, you might say, that we're looking at in the UKCS decommissioning. I've always wanted to have a field named after me, but I'm afraid I won't have. But for you who may not be so familiar with field structures, I thought maybe I would create an Uisdean field. And since we're in Norway, perhaps it could be called the Uisdean field. And I thought I might add, you know, that many of you will be familiar with Houston, Texas, which I've been to many, many times. I lived in Louisiana for 7 years. Sam Houston, you know, was the first president of the independent Republic of Texas. And his name is based on Uisdean. His great granddaddy was of Celtic origin. So I never fail to remind my friends from Texas that their city was named after me. But just to look at the field structure, we've got a red line for cost, and we've got the 5 different time frames of every field. Exploration and appraisal, you've got very high risk cost there, not that much. Development, you've got very, very high cost. You've got the long production, okay? Goes on a long, long way. And the 5th is decommissioning. So we find massive cost up to development, then it falls. We've got no production at all until development. I would love to be able to explain that to the Labour government, just so they understand. But suddenly, you've got great production. That's your best production. It's going to be in your first shipment. Then you start falling. And again, you fall very, very slowly. And I might have added a revenue, but maybe it would look a bit busy. But revenue would have followed the blue. It would have undulated a bit because of the price of oil. But finally, it would have come down here. And eventually, you've got cessation of production. We're out. No more production, no more revenue. And what we find is suddenly there's a massive surge in cost. At the very most vulnerable point, you've got suddenly a massive surge in cost. This is decommissioning. This is decommissioning. Now, if you were to assume that your only business was this field, there was no other business, you would have a massive cost here. And you would have for years very, very low profits. Now, normally in business, you can take back losses about 3 years in the UK is a normal rule. What happens if you try to do that? You cannot get tax relief for this massive amount of money. Some of our old fields from the 1970s are costing $1 billion a pop to decommission. Now, in Norway, you've got rules that deal with all this. It wouldn't be a problem in Norway. If this had happened in Norway and you couldn't get tax relief, you would have deemed tax relief. Production would be magicked to give you the tax relief. But it doesn't happen in the UK. So I ask you to hold this in your mind. This problem is key to the UKCS decommissioning. This one is a key problem. So don't forget the Uisdean field. Let's look very briefly at OSPA, because in fact, everything we do is basically down to OSPA. And where did we get OSPA 98.3 from? From the Brent Spar incident in the mid-1990s. We found that Brent Spar, a large piece of the huge Brent field, is due to be decommissioned. Shell, acting entirely in consideration with the international law, with the national law, proposed to drop Brent Spar into very deep water. But there was a campaign against that, led by NGOs, and even went so far as petrol stations were being bombed in Berlin. Rioting, a lot of trouble. The British government had approved the Brent Spar decommissioning program, but Shell changed its mind. Shell said, look, let's try and do something else. Let's look at other programs. So they came up, I think, with 29 different proposals. Finally, they narrowed it to 2, that they would drop it in the deep ocean or they would bring it on shore to Norway. So it turned out they brought it on shore to Norway at great expense. And OSPAR, which is the regional treaty for decommissioning in northeastern Europe, in the light of that, issued the decision 98.3, which said that there would have to be a clean seabed, with 3 exceptions. One of which would be if there were in steel jackets, there was steel in excess of 10,000 tons weighed in the air, or if there were massive concrete installations on the seabed, or if there was some utterly compelling reason that you just could not safely clean the structure away. With these 3 very limited exceptions called derogations, decommissioning must clean the seabed. That's the current reality. That's what we're working to and what you're working to. But I just ask, couldn't we learn from the examples of other nations who do other things? And in the Gulf of Mexico, you have the rigs to reefs program, where in fact it's possible to work with coastal states in certain circumstances to create artificial structures, which are very good for habitats, which are very, very attractive for recreational fishermen. And over 500 structures off Louisiana have turned into rigs to reefs. And in fact, oil companies must estimate what they save by doing rigs to reefs, and they pay 10% of that to the littoral state, be it Louisiana, Texas, Mississippi. I'm not a scientist, but I would like us to be able to take a science-based approach rather than closing the door, particularly when the British government is so desperate to save money. But we're stuck with OSPAR for the meantime. That's foundational at this time. Now, oil and gas tax. Let's take a deep dive. Let's take a deep dive. There are 4.5 cardinal rules. 4.5 cardinal rules on the UKCS, which we can compare for Norway. Money set aside for decommissioning. Typically, you will create a fund for decommissioning as the field draws towards its end. In the UK, generally, it's done over 7 years or a time like that. So you will be ready to decommission when the time comes. But you cannot, what monies you set aside for decommissioning, neither in Norway nor in the UK, are tax deductible, which is bad for the oil companies, but it's a government decision. They have fears. They have fears about tax deductibility of decommissioning securities. So there's no tax relief until you actually start cutting steel. So you remember the Uisdean field, the cost is all right at the end. There's no tax deductibility until you start cutting steel. That's the same in Norway and the UK. Now, in the UK, we have an extraordinary rule which says that sums expended for decommissioning security cannot be used for any purpose. And not only that, an extraordinary rule that says that even if the company goes into bankruptcy, the receiver in bankruptcy cannot access these funds. They are invulnerable even against bankruptcy, which is an extraordinary rule. I don't know if I've ever come across that happening anywhere else in the world. And here, the third rule is a rule which favors oil companies in the UK and disfavors them in Norway. Capital expenditures can be written off against production revenue on an immediate 100% basis. That favors oil companies in the UK. In Norway, it's depreciated over like 6 years capital. And this is also the normal rule in the UK. But that is an exception for oil and gas companies. Now, we have 4 different oil and gas taxes. The 4th cardinal rule, for purposes of petroleum revenue tax, ring fence, and supplementary, you can take back losses well beyond the normal 3-year limit. We talked about the 3-year limit, and that the whole reason for doing that is the problem that I identified in the Uisdean field. Now, lastly, and you may be amazed that this is a rule that even needs to be articulated. I can't even believe that I am articulating it. But generally, but not without some important exceptions, it's always been possible to take capital allowances against historic oil and gas tax paid. Now, that's a bit jargon, but what I'm really saying is, if you spend money on your business, that should be used to reduce tax. That's the basic, fundamental principle, which should always be applied to all businesses. I feel very strongly about that, but in fact, we are seeing big departures from that in the UKCS, both in the past and in the present and in the future. So this is a really, really serious problem for the industry. Right. Now, the current oil and gas tax regime, you may be kind of surprised. We've got 4 taxes: petroleum revenue tax at 0%. What an odd thing, you may say. Yes, it's very odd, and we'll explain why it's very odd shortly. Ring fence corporation tax at 30%, supplementary at 10%, looks very much like your corporation tax in Norway. And we have an energy profits levy, which began last year, just causing us a lot of problems, at 35%. So we have a 75%, basically a 75% tax system right now. This was driven by the Ukraine war, the rises in the price of gas, introduced by the Conservative government. So we've got four taxes. How are we doing, Ignacio?
Yeah, about 25 minutes.
25 minutes, all right. Yeah. The petroleum revenue tax is again a remarkable beast. And I don't know of anything like it in the world. It's introduced by the new Labour government in 1974. PRT is ring fenced on a field basis. What that means is however many fields you have, each field is taxed separately. So you cannot take profits and losses from other fields against petroleum revenue tax. I'm not aware of any other tax in the world that functions like that. So it's a very, very remarkable beast. It was started by the Labour government, started at 45%. By 1983, it had gone up to 75%. In that year, the overall tax take approached 90% in the UK, even higher than Norway. That was probably the highest ever rate of oil and gas tax there's ever been in the world. And the amazing thing is, it was imposed by the Iron Lady, Mrs. Thatcher. And why did she do it? Because she was in a very, very deep recession, and she needed to raise tax. She was able to raise 1/8 of all British public expenditure from oil and gas. Now, if the UKCS today were to provide 1/8 of the British budget, that would be roughly £120 billion. The tax from North Sea oil and gas this year is about 4 billion. It just shows how the how the industry has changed in terms of its profile. Now, petroleum revenue tax was abolished for all new fields after 16 March 1993, but it continues on all the prior fields, all the big old fields with these huge structures still subject to PRT. The other two taxes are ring-fenced as well, but according to upstream petroleum activity. So there, if you've got various fields, you can bring profits and losses into the equation. Petroleum revenue tax was set at 0% from 1st January 2016, and I'll explain why. I get worried talking about the tax because I know it's difficult to follow, but it's filled with absolutely exceptional elements. So petroleum revenue tax, sums expended in decommissioning against petroleum revenue tax can be taken all the way back to 1974. So if you have a $1 billion hit to decommission, you can take that $1 billion against profits as far back as you need to, even going back to 1974 if you need to, which is an extreme, absolutely extreme rule. But that's the case. And sums expended against the other two taxes, they go back to 2002, which is still pretty extreme. There was, around 2013, there was concern on the part of the industry that relief and decommissioning spend would be restricted or PRT abolished altogether. Because if you abolish PRT, then you get rid of all these refunds. And there comes a time when, in fact, the refunds are worth much more than the tax because the old fields are disappearing. So the industry was very, very concerned about that. And in addition, security was being posted on a pre-tax basis on the fear that there wouldn't be tax relief. So that was making security very expensive. So the response again has been a very remarkable initiative. It's called the Decommissioning Relief Deed. We have 108 of them, where the British government enter into a contract with each oil company to say that even if these taxes are abolished, they will get sums equivalent to the relief that they would have got from them if they hadn't been abolished. I know that sounds crazy, but that's actually the system works, and it shows you the fear that oil companies have been stuffed with that massive decommissioning bill with no tax relief. You know, if you have a 78% tax, your $1 billion that you're spending in decommissioning, the government is sending you a check for $780 million. So that really, really concentrates your mind. Now we have a very serious problem with a new Labour government, which wants to crack down on the energy profits levy. Now they're going to raise the rate to 78%. Somebody looked at Norway and they said, okay, let's try and do Norway. Let's make it 78%. But most importantly, Labour is currently considering scrapping all capital allowances against the energy profits levy. So that it will be not possible on any capital project, whether it's exploration, appraisal, development, production, or decommissioning, there will be no tax relief. So therefore, your 38% will actually be a massive royalty. If there are any economists in the room who know about oil economy, they'll tell you that the worst thing you can have is a royalty. It's a horror. It's like a massive stick smashing through your NPVs. And the fear that exists in the industry, it's being consulted right now, is that this might actually sink every new development in the North Sea. And with developments being sunk, the hubs would start to decommission early. So this is keeping me awake at night because I've got 2 pending UKCS deals And they may not happen if this this terrible tax initiative happens, but it might not. It might not. It might not. So this is the tax background. Now, if you were looking at Norway, you would find that none of this would be there. Very sensible. I mean, you've got very high tax, 78%, but you've got very, very generous reliefs. So just to finish off, the drivers of industry and government. If you've ever been subject to a 90% tax, you are desperate to make sure that your decommissioning, you get back your 780 million for your 1 billion in decommissioning. Desperate. And if you have high levels of tax like that, well, you're going to have big tax write-offs. It's inevitable. But for government, even although the reliefs always comes out of tax already paid, the government does actually have to fund the reliefs. So there's a check being cut by government. And government hates to cut that check. Additionally, there's a political vulnerability because political opportunists allege that it's a subsidy. You will find cases of oil companies who may have very low profit in a year. They've got a big decommissioning. Shell, for example, had a couple of years ago. No, it's a big check being given to Shell. You can also point out that Shell has made $4 billion, but they don't say it has to do with worldwide operations. So subsidy, let me tell you, is one of the worst weasel words you will ever find in the lexicon. When people talk about subsidy, be sure you know what they're actually talking about. So what government is obsessed with, if it's writing off these tax write-offs, it wants the decommissioning to cost the very least possible. And you find it obsessive in the British system. It's also tempted to eliminate relief totally, which is not commendable. And I think it's theft. And I really get upset when I think of that. So much for tax. I hope it hasn't gone over everybody's head, but we've got a problem with tax. Maybe that's what I should have said. Now, decommissioning regulation is, funnily enough, a bifurcated regime. The abandonment of wells is governed by the license, which is Model Clause 19, and the regulator is the North Sea Transition Authority, the NSTA. The decommissioning of offshore installations and pipelines is dealt with under statute law. It's Part 4 of the Petroleum Act 1998, as many times amended. There, the regulator is called the Offshore Petroleum Regulator for Environment and Decommissioning, OPRED, which is part of the Department of Energy. I won't go through the long names. They keep changing these names all the time. I mean, like every massive change in tax, there seems to be a change in the name of the regulators. But I would be very happy if we just leave the regulators' names alone. I don't know how many changes there's been. To me, it hasn't been easy to understand why decommissioning activities are split between two agencies, when decommissioning planning is of necessity a unitary process. But plugging and abandoning, of course, can happen at any time. You know, you drill a dry well at exploration, it needs to be plugged and abandoned. But I've never figured out why why OPRED should have a responsibility. Why not just have the NSTA? I don't know why. I don't know why they don't do everything. They could, but you've got two separate decommissioning teams. So well abandonment, let's quickly look at that. And in order to look at well abandonment, let me just jump on to something which is a feature of the UKCS system. And I don't know if this happens in Norway or to the extent which it happens. I'm hoping to learn that. But here we have a license, fictional license P1777, covering two blocks, 9114B, 9114C. And the two original licensees are AAA and BGI. few months after getting the license, they decide they're not interested in block 914C. So they sell it to Valhalla and Europa Gas. Now, how does this work in the context of the license? Well, Valhalla and Europa Gas immediately become licensees. You don't own percentages of licenses in the UK. You only are license holder. But what the parties do is, us between themselves, through a trust deed, Triboli and BGI say, we really have no interest in this block. Valhalla and Europa Gas say, we've got no interest in this block. But we'll perform our share of the license obligations. We'll perform our share of the license obligations. So in fact, there's different economic interests, totally. So there was two separate GOAs there. But the abandonment of all wells is a license obligation, which is joint and several. Now, it's possible that these two guys could go bankrupt and they've drilled 5 wells. They go bankrupt. The NSTA will look to these two to pay for that well abandonment. So you can actually be liable for the well abandonment of wells that you knew nothing about and took nothing from. That has happened in my experience. But thankfully, we've got very, very few bankruptcies with oil companies, thankfully. You will see that with decommissioning installations, that is not possible. You can only be liable to decommission installations if you've had an economic benefit. So a slight change. Not sure if you do that in Norway. I like to try and find out. So with offshore installations, we're talking about everything from a wellhead, an umbilical, the whole subsea system, the riser, FPSOs, fixed installations, pipelines, all of that stuff is coming under installations and pipelines. To be liable for that under Part 4, you have to receive a so-called notice under Section 29. It's a bit like the black spot. If you've ever read Treasure Island, which you may or may not, rather Anglo-Saxon book, but you get this black spot, you're liable. And who can receive such a notice? Well, with the installations, it's the person managing the installation, licensees, anyone with an economic interest in the facility. For pipelines, basically it's the same. Pipelines, by the way, are not covered by OSPA by 98.3. However, the UK treats them in pretty much the same way, with slight variations. So you try and have a clean seabed as well, with a couple of tweaks. So that, and yeah, so when are these notices issued? Well, just after field development plan is approved, i.e. before you start doing the development. But OPRED, it will only try to finalize the program at the end of the field's life. So it's hanging over you for 30 or 40 years, the license. The 29 holders are jointly and severally liable. And as the field develops, you can keep on adding Section 29 notices. The obvious case would be where license equity is sold, new oil companies come onto the license. They're going to get 29s if they're involved in the development. If these are exploration and appraisal, there's not 29 at that stage. And the notices can also be withdrawn. If OPRED is satisfied that the new licensee is adequately funded, they may just withdraw the notice. But here's another extreme rule. Any company who has ever received a Section 29 notice, or any company who ever could have received a Section 29 notice after the first notice is issued, can be called into the program under Section 34. So the long arm of the British state will get you if it possibly can. The last thing they want to do is to pay for decommissioning. But they never have. They never have. And so far as we know, no company has ever been called back through Section 34. So a little bit more in the decommissioning programs. I just checking out how this works in Norway, and by and large, it works the same way. It's pretty sensible way. You know, you're looking at cessation of production 5 or 6 years out. You want to go early if you think there's a derogation under 98.3. So you're going to consult with the NSTA, which is not the decision maker on this. Consult with the NSTA, and in framing the program, ensure that you try to collaborate with others, that you keep costs to a minimum. The NSTA, which is not the decision maker, would be advising on alternatives, i.e., do you need to decommission this thing? Could you reuse it? Could you do something else with it? And OPRED finally approve or reject the program. Now, cost reduction, if you look at the statutory basis, you'll find it's almost embarrassing. I mean, I get it. They want to keep costs down, but it's mentioned like 7, 8, 9, 10 times in the statute. It's really excessive, but fair enough. I'm all in favor of cost reduction. So that's basically the regulatory system and how the agencies work. And how long have I got now?
10 minutes.
10 minutes. Good. Yeah. Yeah. Well, around after 2010, there was this feeling in the UKCS that the province was failing. This was not a time when net zero was particularly, there was really no net zero by 2050. I don't think, or was there? 2008 Climate Change Act. But in any event, the emphasis was very much on maximizing economic recovery. And Sir Ian Wood, who is like a billionaire in Aberdeen, was hired by the Lib Dem Conservative government to come up with a big plan to revolutionize the North Sea. And he issued his report in February of 2014. Read it so many times, what Sir Ian Wood wrote. And it's interesting because he's writing about oil companies. Sir Ian Wood has never been in an oil company. He's been in a massive oil service and construction company, the Wood Group. But he came up with several very big ideas, one of which was to transform the regulator, to create a new empowered regulator, which certainly did happen. And I've written quite a bit about the extraordinary powers of the NSTA. But additionally, I think this is the best paragraph I can find. This is in Sir Ian Wood's words. This report, his report, details the key principles of MARE, central to which will be the regulator exercising its functions with a view to securing the maximum amount of economically recoverable petroleum from UK waters, and license holders required to act in a manner best calculated to give rise to the recovery of the maximum amount of petroleum from UK waters as a whole, not just that recoverable under their own licenses. Now, when I read that, and Dean Gordon of Aberdeen University, we read that, and John Patterson, we're struggling to understand exactly what they meant by that, because that is not an obligation that any other oil company in the world that I'm aware of has to take on. But we waited for the Infrastructure Act of 2015, which kicked off MARE, and then it was heavily amended in the Energy Act of 2016. And in fact, the MARE strategy, which is a regulation of 36 paragraphs, came out in, I think it was March of 2016, and it's been amended in 2021. So I'd just like to, I mean, there's far too much. I've written exhaustively on MARE and on all its aspects, which are many. But I'll be quick and I'll take you through decommissioning, and then we go on to Q&A. The central obligation, the golden rule of MARE, is paragraph 2. Relevant persons, which I call MARE parties, and I'll define them, basically they're oil companies. Oil companies must, in the exercise of their relevant activities, take the steps necessary to secure that the maximum value of economically recoverable petroleum is recovered from the strata beneath relevant UK waters. and then take appropriate steps to assist the Secretary of State in meeting the net zero target. 2.1a can be read to say, drill, baby, drill. 2.2b can be read to say, net zero, baby, net zero. There's an increasingly a contradiction which is developing in the UKCS between those items. And tax policy could arguably, as well as environmental regulation. I passed you my analysis of Finch versus Surrey County Council, which is in conflict with the goals are in conflict, in other words. The mayor parties, well, they're listed in the Energy Act, licensees and operators and owners of infrastructure. That's the. Now, there's this funny system of safeguards. So the broad mayor obligation is subject to safeguards. There are 4 principal safeguards. Firstly, no mayor obligation involves an obligation to act contrary to law, to the license, or to common law. It doesn't say, it doesn't include private contracts, which again is a subject I've been very interested in. Does mayor rule over private contracts? I'm actually facing that right now, that issue. And I don't know whether it does or not. Secondly, no mayor obligation will require a mayor party to make an investment in which they would not make a satisfactory expected commercial return. Thirdly, where mayor requires a mayor party to make an investment which is wholly or partly for the benefit of a third party B, then B may be required to contribute, but any such contribution must be reasonable given the mere importance of B's assets. Try and work that one out. Tell me what it means. Lastly, no mere obligation requires conduct under which the benefits to the UK are surpassed by damage to investor confidence. And there comes the ghost of Brent Spar, the social license ghost, the policy ghost of we'll do something if it's okay generally. So there are 3 decommissioning paragraphs. I'm not going to deal with the third one because it's just simply too obscure. But the first paragraph is paragraph 15. Before commencing the planning of decommissioning, mayor parties must ensure and be able to demonstrate that viable options for the infrastructure's continued use, including for reuse or repurposing for carbon capture and storage projects, have been suitably explored. The UK does not currently have a single molecule of carbon dioxide which has been carbon captured. I'm not talking about EOR, not enhanced oil recovery, because that's actually there to produce oil. We don't currently. Norway does, I think, have 1 project. But according to Labour, by the time 2030 comes round, we should be leading the world in carbon capture and storage. Let's see if we do. Paragraph 16. Mayor parties must decommission infrastructure located in UK waters in the most cost-effective way that does not prejudice the maximising of the recovery of economically recoverable petroleum, including any reuse or repurposing options. When I read that, the very fact that you're decommissioning infrastructure means that you are likely prejudicing the recovery of economically recoverable petroleum. There's a contradiction. Lastly, this includes ensuring due regard is given to the obligations in paragraph 13. Let's briefly look at paragraph 13, technology. Relevant persons, the mayor parties, must ensure that technologies, including new, emerging, and existing technologies, are deployed to their optimum effect, and where appropriate, encourage the development of such technologies for the purpose of maximizing the value of economically recoverable petroleum, including in relation to decommissioning. This actually is law. It's something that's mandatory, but it's mandatory to encourage. That's a very odd legal construct. You're not usually legally obligated to encourage something. And lastly, collaboration, which we found in the statute. In undertaking relevant activities, mere parties must collaborate and cooperate with other mere parties. Persons seeking to acquire an interest, forget that. Persons providing goods or services, which is the supply chain. You have to collaborate and cooperate. It's a legal duty. Now, I'm all in favor of collaboration within economic entities. I don't honestly know how you can legally require cooperation between separate entities. So a lot of really mind-stretching language. But that's really the end of the substantive lecture. What I haven't covered, what should be covered, a broader review of the relevant international law of the sea. Now, we've got the expert. That's the one thing I wouldn't want any questions on, because if you've got any questions, Mr. Ignacio, he knows a lot more than I do. Perpetual liability. I am going to be an examiner, outside examiner for a PhD on perpetual liability. I'd love to speak about it. We don't have time. Decommissioning security agreements, treatment of decommissioning, the standard GOA, supply chain modalities, model forms, including our logic series. All of that is something I'm tremendously interested in. And my next big article is actually on that subject, which will be in September. There's no time to talk about it. And then how to pay for decommissioning security, the role of insurance, the assessment of financial adequacy. All of these things you could easily have lectures, of hours on, but I will leave them for Q&A. And that's it. How did I do?
Wonderful. Thank you so much. So Uisdean, you have really challenged us because you really brought the lawyer into the room, right? So you have spoken like a true lawyer, and that you have spoken advocating for the different clients and the different needs that we have. And we have spoken about different elements that most of the ones that are taking energy law have no idea of what he has spoken yet, because we have not spoken about all of these things. But having your presentation today, which is about the end of lifetime of the wells, is going to make a lot of sense when we have been covering other aspects, because we'll say, oh, now I understand why he said this, or now I agree with him, or now I disagree with him. What I will do now is we will stop sharing the video now, and I will stop also the recording of the seminar.
Got some friends on there.
Yes.
Styles.